Hello everyone. For today's Murphy Law Monday, I want to touch on the topic of what to do if the other parent would not allow you to see your child. And specifically, if you guys do not already have a court order or an agreement that says otherwise. First of all, if you do have a court order, I would advise you to go to the police station or call the police non-emergency hotline and tell them that you have an order that you would like to enforce, and that the other parent lives at this address. You might need an escort to take you to that address to get the child from the other parent. That is not the best advice if a situation is not hostile. My advice, of course, would be to try to communicate with the other parent first before you involve the police, because things can get really hostile when police are involved, and specifically for a child, they don't like to do that with children. But if you're being denied access, that's an option. And in addition to that, if you did have a court order or an agreement that says something that you can present to a judge, and you believe the child is in danger, not just that you didn't see them or you haven't been seeing them, that they are in danger, that you have a basis for danger, i.e. the child calls you and said that they're locked in a closet, or they called you and said they witnessed something from the parent getting abused or something like that, something that puts them in danger. They're out of state, they're driving in the car going to California from Maryland. Those are situations where you can file an emergency petition, but I would limit those because emergencies are rarely granted, because there is rarely a situation where a child is in danger. Next, if you do not have a custody order or an agreement formally executed with you and the other party, my advice, of course, is to file for custody and to tell the court what arrangement you were doing with the other party and why you believe you should have a custody order in place, and specifically highlighting that you haven't seen the child since this date and the other party is ignoring your calls, ignoring your texts, or whatever. Even if you did have a court order, you can also file a contempt, and I urge you to file a contempt as soon as possible, not wait until months pass, weeks pass, days pass, because your argument for contempt loses its weight as you let time lapse. I had a client once before who waited for 16 years before he filed a contempt for a denial of access, and I just couldn't believe that. I couldn't believe that he let 16 whole years go by without seeing his child before he successfully pursued the counsel of an attorney to get the case in front of a judge for contempt. And by that time, the child was old enough to say, I don't want to go. So there's a shaky situation, and I think when you're letting time lapse, you need to be cognizant of that. And I also think you should make sure you're documenting text messages, emails with the other party, communicating your intentions to see the child, why you want to see the child, etc. Just wanted to give you guys that tidbit. If you're in need of legal services in the state of Maryland or in the District of Columbia, please give my office a call, 240-493-9116, and www.amurphylegal.com. Thank you.